right, hello again. This has been His Card talking to you today, and what do I got? It really is almost too funny. So we have a MPS, a school district, filing a motion on behalf of Calvin Ferman, a hearing examiner, to another hearing examiner, Larissa Benitez Morgan. It's almost too much. It's almost too much. But yes, you heard it. That's what happened. So let's go over the course of events. All right. First is Angela Ford, and her case involves discrimination in terms and conditions of employment at MPS and the curriculum department. Where have we heard that before? Also from Debbie Keither, also from Jose Garcia Hoven, and in terms of race. And basically, part of the contention there, or the allegation made by Miss Ford, is that she was standing up for Garcia Hoven in his case. In his situation, she was, working with her fellow coworker, regardless of his skin color. And she was explicitly told by Dr. Holliday that she should know what team she's on, something along that effect. I'm paraphrasing here, but the testimony, as I recall, is that I he pointed to the skin on his forearm and said, "You need to know what team you're on," something along those lines. Now, who supervised Dr. Holliday at that time? It's my understanding that it was Calvin Ferman. Well, that's interesting. It's also my understanding that Calvin Ferman assisted um, Holliday in filing a discrimination complaint against Milwaukee Public Schools, alleging bad actions by Keith Posley, the superintendent. Uh, so that is the allegation that stands there from Ford, and sort of part of, anyways, the reason why Calvin Ferman knows about uh, the facts surrounding this case. You may recall that Larissa Benitez Morgan, some less than 20 days, I think it was 14 days, again, before the hearing, canceled the hearing and dismissed the entire case. And some year and a half later, or something, the case was reinstated for discovery by the Labor and Industry Review Commission. What really frustrated me about that was that a very similar decision had come out 3 months beforehand on about Gelhard uh, conduct, doing very similar thing. That we presented that to the judge at that time, and she took no action on that. I also think that it may have been appropriate for Lurk to have mentioned that in his decision, but you know, there was a lot of ground to cover, I guess, is another way to look at it too. But I did find that to be um, part of the issue here. Although there was many technical grounds to disagree with the decision, I think that the larger context, which is the fundamental unfairness of a lot of the things that are going on, including the hot mic person. Um, I do believe that we asked to have the hot mic recording added to that case in evidence, and I don't think that they actually looked at it, or as soon as it seems like the decision came out soon thereafter. And I'm not criticizing anybody necessarily, but I am saying that, um, well, they're a review function. I get it, but I do think that um, let's put it like this. The words of Lurk are what these ALJs most keenly feel, because they are not apparently supervised by their supervisor, at least according to any of the public records requests that I've seen. So I think that that's a big part of what these decisions are. Anyways, it goes back to Larissa Benitez Morgan for discovery. So we file a subpoena on Calvin Ferman. That's totally inaccurate. We contact Calvin Ferman about his appearance, discuss a date, and send him a notice of deposition along with to MPS, which is they're the opposing side. I think that's all accurate. MPS asked us to agree to not publish the depositions on this channel until the case is over. I think that's fair. And I think it's also fair that my client did not agree to that. So then what happened is that MPS, and see again, key important fact. Calvin Ferman is represented by MPS in, for example, the Debbie Keither matter. I assume because of insurance. I don't know why, but he's not represented in this in the Ford case by MPS. Important fact, because here, part of what we can report is that Milwaukee Public Schools filed this motion for a protective order to first they try, and this is important, first they tried to file it with Maria Selsor. And they acknowledged that the reason that they tried to file it with Maria Selsor was because of issues that I had raised with conflicts of interest with Calvin Ferman. And Maria Selsor, it said for, I think, one of the first times ever, that she didn't make decisions on cases, that it was up to the administrative law judge, and her role was more to assign cases to people, which in my mind was like fireworks going off everywhere. Hip hip hooray! Um, hip hip hooray! That's baby steps, I think, but in any sense, somehow they got the concept. Um, and maybe just prospective and not and they are going to struggle not to set any precedent, but we'll see what happens. So if I'm boring you, let me know. All right. So as somehow though, the case is actually then technically assigned to Larissa Benitez Morgan, even though it had been assigned to her essentially by alert. Then they had MPS refiled the motion with her, and then I get without not an email, I get a letter some days later saying that she had recused herself. Now, here's the key fact. Says that she recused herself for perceived personal bias. Well, the problem there is, first of all, I don't know of anybody who perceives her to have any personal bias. But more importantly, there needs to be some facts on the record as usual. As always, we've gone, I mean, this has got to be the third time here, but even in this particular case, in the Ford case, there are no facts that say that somebody perceives Benitez Morgan to be biased. And certainly we wouldn't know because she hasn't pointed to him. The sole comment that she's made yet again is because of perceived bias, which is what she did in Stolar, right? She said that then it went to lo and behold, it went to Stephanie Brown. So um, those are very concerning developments here because yet again we're playing this game. So now is what, Calvin Ferman forever out of penalty or exposure of discovery? I don't think so. You know what? The case is just going to sit there again for 3 months, like it did for Folaron, while each judge sits there and recuses himself because of Calvin or perceived bias. I don't know. Um, but that's it's another one of these interesting situations at the Department of Workforce Development um, that have occurred. and we're here to report them to you. So, um, I think you got it. Thanks for sticking with us. Oof, one of these days we'll keep you informed.